Good evening to one and all present here. It's my pleasure to welcome you to today's online lecture on ethical and moral issues in intellectual property rights. We are honored to welcome our esteemed speaker for today's lecture, Ms. Tanisha Ranjan. Ms. Ranjan is an assistant professor at Rashtriya Raksha University, Gandhinagar. Ma'am is also a licensed advocate with a robust academic and professional background in law, particularly in IPR. She holds a BA LLB degree from CMR Law School, Bangalore, and LLM from National University of Study and Research in Law, where she is also currently pursuing her PhD in the field of IPR. Ms. Ranjan has served as an assistant professor of law at Jharkhand Raksha Shakti University and interned under the distinguished Mr. Salman Khurshid, gaining an invaluable experience in the Supreme Court and other legal arenas across India. Her expertise is further reflected in her numerous publications, including New Age Tussle with Legal Measures in Controlling Counterfeiting Practices and India Protection of Non-Conventional Trademarks. Today's lecture will tackle the complex ethical and moral questions that arise in the realm of intellectual property rights, examining issues such as balancing the interest of creators and society, as well as the implication of emerging technologies. Ms. Ranjan's insight will guide us through these challenging topics, offering valuable perspectives on the intersection of law, innovation, and ethics. Now, without any further delay, I shall request Ms. Ranjan to kindly proceed with the session.
Thank you, Aditya, for the warm introduction. I just want to confirm that am I audible to everyone? I am. Aditya,
Yes,
please.
ma'am, you're audible.
Okay. Okay, thank you. So before starting the lecture, I would like to thank CSR IPR for inviting me because, uh, and also thank, it's my privilege to be part of CSR IPR family again, but from the other side of the table. So thank you very much. So moving on to the topic, ethical and moral issue in intellectual property rights. So we all know that what intellectual property right is and what are the types when we talk about trademark, copyright, GI, traditional knowledge. So these are the basic types of intellectual property rights. I won't be going into basics of what intellectual property right is, but when we talk about IPR is a legal framework. All right, it is a legal framework which gives protection to those intellectual mind who has created something new or who has invented something new, right? And this legal framework is regulated in such a way that it provides an exclusive right to in the form of incentives or the mechanism of compensation. So this exclusive right is the main element which intellectual property rights provide to the holders of IPR. So this is what a general meaning of IPR is. But when we talk about this exclusive right, and when we see keeping this exclusive right in the surface, we see that beneath this exclusive right is a complex web of ethical dilemma, which is challenging right now, which is a major concern. Because in one hand we talk about IPR and we talk about exclusive right of the IPR holder, uh, and also in one hand we recognize that IPR leads to development. It leads to it is also a motivation for other, because it provides exclusive right, and it motivates others to come up with new ideas and creation at the same time. So but on the other hand, when we see there is a societal need, which is, and there is a tussle between IP right, exclusive right over IPR, and societal needs, and there is when ethical and moral issues come into play, right? So we will be dealing with what, firstly I will be explaining what ethics means, what morals means, but I won't be explaining directly, or I won't be jumping directly into the meaning of ethics and morals. First I will be mentioning a landmark case, and with the help of that particular landmark case I will explain the meaning of ethics and morals. Okay. And later, in the later part of the lecture, we will deal with ethical and moral issue, again with the help of a case landmark case laws. So this is how we will move on to the entire 1 hour lecture. All right. So to the coming to the case where we talk about where we will be understanding the meaning of ethics and morals. So there is a case, Bear versus Nacto case. Bear versus Natco case. So in this case, where Bear Corporation is a German company who has invented, we are going to the facts of the case. So Bear Corporation is a German company who has invented and patented a drug named Nexavar. So this drug is used for the treatment of kidney and lungs cancer. So, point to note here is a treatment of kidney and lung cancer is a life-saving drug, a huge deal, right? So, it's a life-saving drug. So, first point we have to note it here. Now, they have patented the same in India as well. So, Bayer company has patented the Nexavar drugs in India as well. So, in India, it is being sold at the price of, please note this, at the price of 2,80,000 per month. So, from the price itself, it's very clear that only the rich people can afford a life-saving drug, and at the same time their company has a exclusive right over it because they have patented the medicine, right? They have patented the medicine, and in a one way, it's fair enough to, they have monopoly over the price. It's fair enough because they have gone through research and development, clinical trials and everything, and the whole the process of making the drug, and finally they have come up with a life saving drug. So it's fair enough. And also they have the exclusive right. So now what happens is Nacto Pharmaceutical is a Indian based company who manufactures generic medicines. Okay, so they approaches Bayer company and they ask for voluntary licensing कि आप हमें voluntary licensing दे दो for manufacturing of your drug. So they denied the request. So what they did was they now approached to controller for and applied for compulsory licensing on contending that Nexavar is firstly a life-saving drugs and it should be accessible to every people, public at large, at affordable price, and the price which they were putting forward was 9,000 per month. So here you can see in one hand the price of the drug is 8,20,000, and now the price of the drug which Natco is offering is 9,000 per month. There is a huge difference, and from this 9,000, it can be available not only to rich but also to the general public, right? So this was the fact of the case. Before moving on to what ethics and moral means, I would like to explain few important terms which I have just mentioned. First is voluntary licensing and second is compulsory licensing. So basically what licensing means in general is when one person who is the owner of particular thing gives the permission to other person to use, to make, or any kind of restricted right over that particular thing, right? So when we talk about licensing and patent, when a patentee gives any individual or organization any permission, it gives permission to use their patented product or manufacture their patented product or sell their patented product. So what voluntary licensing means here is, voluntary licensing is when the license is given with the permission of patentee, with the permission of patent holder, to any particular individual or any particular organization. So this is what voluntary licensing means. All right. Compulsory licensing is when the license or when the permission to use, to manufacture, to sell is not given by the patent holder, or not by the permission of patent holder, rather the permission is given by the third party to any individual or organization कि हाँ चलो अब आप क्या कर सकते हो, you can sell, you can manufacture, you can make use of the patented product of the patentee. So the third person can either be controller, or it can either be the government, which is used for a public good. Now, so I believe that the concept of voluntary licensing and compulsory licensing is clear here. Okay, so voluntary licensing is with the permission of patent holder, compulsory licensing is without the permission of patent holder. So now here the question arises is it is it morally right to use your patent या your product without your permission? आपके परमिशन के बिना क्या मैं आपका सामान यूज कर सकती हूँ? Is it morally right? So you will say, no, ma'am, it's not morally right. Yes, it is not morally right. We have to take permission before using the product. So in this case, is it morally right to use the patented product without the permission of even patent holder? No, right? So now second question here arises again, is it ethically right to think about the public at large, to this public interest, because that particular drug is a life saving drug? You will say yes, and here is where there is a tussle between moral and ethics. So what moral means is what is moral means your personal beliefs, your personal feelings. We all know that personally it is wrong, बिना परमिशन के we cannot use anyone's product. It's a feeling, it's a belief, it's a value, right? So the moral means personal beliefs, personal feelings, personal values, which drives the behavior of an individual, whereas ethics talks about the principles, the rules of what is right and what is wrong. Though we know that it is morally wrong to use anyone's product without their permission, use anyone's patent without their permission, but it is ethically right because it is for the principle of justice and public interest. It is for the principle of public interest. So this is what is a difference between moral and ethics. Moral is the personal belief, ethic is the values, the rules, the principle which governs the conduct of individual. So here, if I say a statement that if anything is morally wrong, need not to be that it will be ethically wrong as well. अगर वो morally wrong है तो ज़रूरी नहीं है कि वो ethically wrong भी होगा, right? At the same time, it can be morally wrong also, ethically wrong also. We will deal that this particular element in further lecture. So in this case, we can say that what is morally wrong need not to be ethically wrong as well. यहाँ पे ethically it is right because it is life-saving drugs, it is for the public interest, it is for the public societal need. There is a societal need for this. So this is what we mean by moral and ethics, right? I hope that everyone is clear with the general meaning of moral and ethics. Now we will move on to the issues, the ethical issues and the moral issues which we face in intellectual property rights. So I will be explaining it again with the help of landmark case laws. First case law which I would like to mention, or I would like to talk about, is the Basmati case. The fact of the case says that there is a company named Rice Tech, and it's a US based company. So Rice Tech patented a varieties of basmati, stating that there is a variation. They have mixed basmati with their variant of rice, and now they are cultivating basmati, right? And they have named that particular rice as those varieties as American basmati, taxmati, because rice tech belongs to Texas. So taxmati, where there's one jasmati also. So by these names, they're selling the basmati rice. But we all know that basmati has been cultivated and it is being grown in India as well as Pakistan बहुत पहले से, है ना? तो here we can say that basmati is a traditional knowledge of India and traditional knowledge of Pakistan. So this is one case. The second case is neem case. So what neem case is, so there was a European company uh, who invented a method of extracting the neem oil and using it for the fungal disease. They're using that neem oil for the fungal disease. Now, we all know that, and they have patented this thing of neem. Now, we all know that from the very beginning, from the centuries, from our dadi ke time se hi, neem is something which we are using for medicinal purposes. Specifically, when I remember during any of my family member suffered from chicken pox. So neem was the something which we used while bathing, or yeah. So basically we all know that neem has um, a medicinal purpose, and it is not something new to Indians, right? So now again, in this case as well, neem is a traditional knowledge of India. The third case which I would like to mention is the case of turmeric. Turmeric case, where the two Indian origin scientists in USA, they patented turmeric, the healing nature of the turmeric, कि वूंड पे लगाने पे, टर्मरिक लगाने पे वो हील हो जाता है. दे पेटेंटेड दिस पर्टिकुलर थिंग. नाउ turmeric is in India, when we talk about the essential value of turmeric, or when we talk about necessity of turmeric, it's a staple thing when we talk about in our food, in our tradition. Turmeric is used everywhere, and also in Ayurveda में यूज होता है turmeric. During COVID-19, everyone was like drink haldi doodh, and also we all know that turmeric has this antiseptic or anti-inflammatory and also medicinal values, and it is not new to us. And we have used again, just like neem, we have used this from our दादी के टाइम से ही, बहुत पहले से. So we even don't know कि कब से ये चला आता जा रहा है. So this is again a traditional knowledge of India. Here, uh, what are the ethical issues and moral issue we are facing? Because at one side they have patented the process of extracting the oil because it leads to it cures fungal disease. The antiseptic, anti-inflammatory, what innovation of turmeric, because it has this particular ability. And when we talk about basmati, it talks about their contention is कि basmati plus they have mixed the variant, and that is new thing. But the common factor here is about traditional knowledge. The every single case law which I mentioned has a traditional knowledge which has originated from India. Here the tussle lies between, or the moral or ethical issues here can is what, when we talk about the patenting, when we talk about the profits, but what about the culture value of indigenous people? What about their uh, have you ever given compensation, or have you taken permission from them? Because the India is a originator of that particular thing. Have you taken permission? No, right? Have you, are you giving any kind of compensation? No, right? So you are patenting them, you are making use, you are enjoying your exclusive right without this. So I will be mentioning few of the ethical issues which has come up in these cases. First issue is ethical issue of biopiracy. What biopiracy means is when any developed country, so when any developed country or individual of developed country or organization of developed country exploits the traditional knowledge of developing or underdeveloped country, or exploits the traditional knowledge of indigenous community of developed or developing country without their knowledge and without their permission. Here the ethical issue lies that you, they have exploited the traditional knowledge of indigenous community of India without their knowledge and without their permission, right? Second ethical issue is that all the three cases, it is a knowledge of public, common public knowledge, common community knowledge, not a knowledge of particular individual. If it is a knowledge of particular individual, how can a organization, um, individual organization or individual person have exclusive right? It is something, it is a traditional knowledge, it is a knowledge of community, it is knowledge of people, and not the knowledge of an individual or individual organization. So from this case we can, from these case what we can come up with ethical issue of IPR is one biopiracy, and second is the knowledge of common people. Now coming to moral issue in these three cases, the first issue is we have given more importance to IPR over traditional knowledge, over the knowledge of a community. So how we have given, I will be explaining. Now there is no profit sharing. यहाँ पे कोई profit sharing नहीं हो रहा with the people who have actually originated or who have found this characteristics of neem, who has found this characteristics of turmeric. So we are the people, the community is getting no profit sharing. We are preferring tradition over economy. uh, we are preferring culture over the economy, right? As the result of it there is loss of culture. So these are the personal beliefs, these are the personal feeling, and these are the moral issues when we talk about ethical issues related to these three cases. So this is the ethical and moral issues which I just mentioned was only related to these three cases, uh, just for your better understanding. But when we come with, when I talk about in general issues in general related to IPR, the first and the foremost issue is issue of monopoly. So exclusive right is monopoly. If there's company, I'm not saying Bear Company was wrong in putting the price of 2,80,000, but I'm just explaining the fact that that term exclusive right has given such monopoly to the companies to make or to fix the price of their patented product when we talk about pharmaceutical industry, right? So here monopoly is one of the ethical issue which IPR faces, and up till now it faces. It's there is a term generic medicine and branded medicine. So during that's why there is okay that's why there is a limit in patent, 20 years, and after that it is open to the public, or limit in any of the ip, right? Why this limit has been put, be it 10 years, be it 20 years, this limit has been put because to avoid the monopoly. Yeah, to it's a solution to the monopoly, right? So but 20, for 20 years they will be having monopoly, and it is a ethical, major ethical issue which we are facing. And yes, we are trying to create a balance between this ethics and ip right holder, because with the help of compulsory licensing is best example where we are trying to create an equilibrium between the interest of right holder and the societal needs. Then uh, 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 compulsory licensing is one. Apart from that, I will be mentioning through which we can balance this equilibrium. So, monopoly is the first case, your first ethical issue. Second ethical issue is access to essential medicines. Um, Again, it is from the very case which I mentioned, access to essential medicines. As I mentioned, there are two terms: branded medicines and generic medicines. Now, branded medicines are those medicines who are within the term of 20 years of patent. है ना? And generic medicines are medicines when patent is over, the manufacturers have this information how to manufacture that particular medicine, and they now as they haven't invested on their research and development, तो रिसर्च एंड डेवलपमेंट के लिए ब्रांडेड मेडिसिन महंगे होते हैं, बट जेनरिक मेडिसिन बनाने वाले दे डोंट हैव रिसर्च एंड डेवलपमेंट का इन्वेस्टमेंट एंड ऑल, दे जस्ट हैव टू मैन्युफैक्चर दैट पर्टिकुलर मेडिसिन, सो द price of that medicine is low. But then, during this entire period of 20 years, the access to medicine comes into question. Just because medicines are so expensive that it is the the major basic element or basic need, I would say, or the basic factor of medicine is it should reach to the people, it should reach to the patient who requires it. If it is not reaching to the patient who requires it, it is not playing a role, the medicine itself is not playing its role, right? The major factor, reason why it has been manufactured. Access to medicine is another ethical issue which is coming up. And yes, there are government are promoting generic medicine. You can see in various lecture our pm has mentioned that kindly use generic medicine. It is the perception of the people that generic medicines are of lower quality, it does not perform well as that of branded medicine and something like that. But there has been studies where it has been mentioned that generic medicine has the same salt which branded medicine has, and even our pm has promoted it and has requested the doctors to prescribe generic medicine over branded medicine. So this is the second ethical issue. The third ethical issue is cultural appropriation and indigenous knowledge. So, what do you mean by culture appropriation and indigenous knowledge? So, culture appropriation again leads to, uh, I will be coming back to our a case law which I mentioned right now. Cultural appropriation and indigenous knowledge. Here, the ethical issue here lies is our culture is diminishing. Um, we are promoting economic growth over the culture. So this is the when we talk about morally, that morally, when we see ki our culture, जो हमारा culture था वो धीरे धीरे जा रहा है, right? And ethically we are saying कि yes, it is contributing in economic growth of the country at the same time, but we are somewhere losing our culture as well. So again there is a tussle between IPR and ethics, right? When we talk about basmati, when we talk about neem, when we talk about turmeric, so there is a tussle between IPR and our culture. uh, Now the last ethics, which is corporate responsibility, it plays a very major role, because what corporate now does is, or specifically focuses on profit making. It only in most of the, I won't generalize it, but yeah, most of the corporate faces, or the most focuses on profit making, wherein when we see patent ka essential criteria for the registration, it should be useful, industrial application hona chahiye uska, it should reach people, it should be for the people. Be it not just patent, be it copyright, be it trademark. Why this IPR is, if there is no public को reach out नहीं हो रहा है, it is not for the welfare of the public, then what's the point of having an IPR? And if that particular invention does not have the public industrial application and use in public, that application is useless. So corporate responsibility is Wi-Fi got cut. Am I audible?
Yes, ma'am, you are
Okay.
now.
Yeah. So where were we? Yeah. Okay.
Ma'am, I think the internet is getting a bit lagged in between. Right now, also it got lost.
It's fine now.
Yeah, ma'am, it's fine now.
Okay. So yes, there is corporate responsibility, wherein profit making, well and good, you should be, because you have worked on it, you have invested on your research and development, you have made the entire medicines and everything. You have every right to gain profit out of it, right? But at the same time we should consider, we should not only focus on the profit making, but also we should focus on the ethical part of, or the major aspect of what IPR is. IPR, or what the basic criteria of any IPR, or basic aim of any IPR is. Yes, it has basic aim of exclusive right, but at the same time, if people won't be using, if people won't be recognizing your brand, how will you gain a goodwill? How your brand will grow? If people won't be using your invention, how will you be gaining profit out of it, right? So people plays a very important role in it. So a balance can be only created where where the IP holders does not only focus on profit making, but also they focus on the individual and public at large, their need, and recognizing their needs and everything. So corporate responsibility is the ethical issue which we are facing, because now the most of them are focused on gaining profit. So this is one of the important ethical issues, and also moral issues which we are facing. So moving on to the last part of my lecture is, how can we balance this? See, I won't give the statement that the tussle between IPR and ethics and moral issues will be completely gone. मतलब वो सॉल्व नहीं, completely solve हो जाएगा. The tussle won't be completely solved, and it is my perspective that somewhere IPR. I think I faced. Okay. So there will be tussle, but what we can do is we can somewhere try to bring try to reduce this tussle, try to reduce this conflict, and try to bring a bit of balance. If the difference is this much, we can, with the effort, we can bring it to this much, because both IP is very important. It is important. At the same time, public interest and societal interest is also important. So both are something which are very important. We cannot ignore any one of them also. We cannot ignore any one of them. What we can do is somewhere we can lower the space between them. So how can we lower the space? First is by fair pricing. Okay, we have exclusive right.
Ma'am, I think we have
Okay,
lost
we
you
fine,
again.
but then I think I'm facing a bit of network issue. Oh, just a minute. Yeah. So yeah, fair pricing is um, one of the ways where uh, we can lower the gap between them. Second is ethical business practices. So promoting ethical business practices, not just focusing on profit making for entire 20 year of time period or 10 year of time period, just not focusing on profit making, but also considering the fact that IP is for the public. IP is the public is someone who should be who should also be benefited from IP. And not just IP is not just about the rich, but it also is about people at large, people who are general common people, society in general, and not just people who belongs to upper class, right? So there should be a ethical business practice. And lastly, I feel that there should be awareness or education, ethical education. We don't know what should be done, what is when we talk about ethics, कि क्या सही है ethically, क्या सही नहीं है ethically. So there should be a awareness or education, not just given to the organization, but also shall be for individual organization, and every single person should be aware of it. कि yes, there is a problem which is very concerning. There is a tussle which is very concerning, and the tussle between two is both of the aspects are very important. So what can we do, what cannot we do? So ethical education will somewhere decrease this gap of between IP and societal interest, human right. When we talk about human right, because when we talk about access to medicine, we have human right of health, right? even it has been given under constitution internationally, UDHR and everything. Every person has a right to health and healthy environment. So these are the few things which I believe that they can play a role in balancing. A complete balance, according to my view, I might be wrong or subject to contradiction. um, the balance is somewhere, there will always be a tussle, but we can play a role uh, in balancing them, right? So this is what I complete my lecture here. I hope that you understood what I wanted to give the basic idea. The dimension of ethical and moral issue in IPR is there are a lot of dimension to it, but then I majorly wanted to focus on the basics of it, because if we don't understand the basic, we won't be able to understand the different dimensions. Maybe next time I will be dealing with the other dimensions. So yeah, over to you, Aditya.
Thank you so much, ma'am, for this very insightful session of yours. So now we would like to open the floor for question, if there are any, and the participants will use the chat box in order to ask their question. Ma'am, in the meantime, I have a question. I got a chance recently to work on a paper that was related to GI and IPR. There I came across a component that was fair pricing, which you also mentioned in the last part of your session. So, ma'am, I had this question while I was pondering the same question that time also, that should the government interference, if they are in any, should it be limited or should it be, kind of more maximized in order to provide a better fair pricing? What should the government do? What should be the level degree of government involvement in these things?
See, I will be referring this with the help of compulsory licensing. So when we see compulsory concept of compulsory licensing, it can be given by the government as well. And there is a very good example of COVID-19 vaccine where government interfered, right? So yes, sometimes interference of government is required when we talk about fair pricing. To what extent, it can't, a particular extent, a particular number can't be given, because we cannot give a particular number ki 50% you can interfere or 20% you can interfere, because law is something in general. When I talk about law including IPR, it's something which is situational based, fact based. Every situation has every situation has different way of dealing. Every situation has different intensity. When we talk about COVID-19, the intensity of the situation was very huge, right? So there was a serious intervention, requirement of serious intervention and interference of the government, because it was a pandemic. But at the same time, when we talk about the next hour, if I take an example, so it is not a pandemic situation, it is a life saving drugs, but not everyone faces this problem of kidney and lungs cancer. So here the interference which is required, the percentage of interference is lesser than that of pandemic. So I think I can't be giving the percentage or how much a government should interfere, but yes, wherever it is required, the government should interfere, and they are interfering through compulsory licensing as well.
Got it, ma'am. Thank you so much for this holistic answer. So, ma'am, we don't have any question per se till now. So, we'll just like to end this session. And as we draw this very enlightening session to a close, I would really like to extend a heartfelt gratitude to you, ma'am, for sharing your deep knowledge and insight with us today. Your expertise and clarity on the topic ethical and moral issue in IPR has been truly invaluable for all of us. At the same time, I'd also like to especially emphasize and provide a thank you to the organizing team, whose efforts behind the scenes made this lecture very possible and very seamless. Now, once again, thank you all of the participants, all the witnesses for joining us, and we look forward to seeing you at our more future events as such. Thank you, ma'am. Thank you so much.
Thank you, Aditya, for being such a good host. And
Thank you.
again, thank you, CSR IPR family. I would like to thank Murthy sir and Shamla ma'am and the entire team of CSR IPR for organizing this and inviting me. And yeah.
Thank you, ma'am.